Bonjour, hello, and welcome everyone. Thanks for being here with us this afternoon for our roundtable discussion with 4 contributors to this new and very important book, which is also for sale out there, The Notwithstanding Clause and the Canadian Charter, Rights, Reforms, and Controversies, published by McGill Queen's University Press. Je m'appelle Jennifer Elrick et je suis la directrice par intérim de l'Institut d'études canadiennes de McGill pour l'année 2024-2025, pendant que Daniel Bélan est en congé sabbatique. I would like to begin by acknowledging that McGill University is located on land which has long served as a site of meeting and exchange amongst Indigenous peoples, including the Haudenosaunee and Anishinaabe nations. It is important to us at MISC to recognize the significance of the land on which we work, study, and live, and to acknowledge the complex web of relationships of which we are a part. We encourage everyone here today to seek out more spaces for learning and understanding the history of these territories. The McGill Institute for the Study of Canada, or MISC, is the Centre for Canadian, Quebec, and Indigenous Studies programs at McGill University. MISC supports a multidisciplinary approach to the study of Canada by bringing together students, researchers, and practitioners to discuss important issues about the country's past, present, and future. In addition to our academic programs, MISC also hosts public events, such as this book launch, or roundtable today, on a wide range of topics that are important to Canadians. You can learn more about our work at mcgill.ca/MISC. I'd like to start today's event by introducing Robert Leckey, Dean of the Faculty of Law, the co-sponsor of today's event. Robert Leckey is a full professor at the Faculty of Law, where he teaches constitutional law and family law and conducts research on those areas. A former law clerk to Justice Bastarache at the Supreme Court of Canada, he is an avocat emeritus of the Barreau de Québec. He has been Samuel Gale Professor and Dean of Faculty of Law since 2016. I will now ask Robert to introduce our other roundtable panelists before we move on to today's discussion. Robert, the floor is yours.
Thank you so much. Yeah, thank you so much, Jennifer. It's always a pleasure for me or for the Faculty of Law to collaborate with MISC. This is not our first time, and we always enjoy the opportunity to do so. So my thanks to you and for Danielle. We weren't imagining that the welcome would be quite so warm when we were picturing sort of late September, but it's great to see so many people here with us this afternoon and many familiar faces in the audience. When Danielle and I began the discussions, we were trying to think who might be suitable, who might we have on the panel, and I'm so thrilled with the group we have this afternoon. It's not working, is it?
It is.
It is. Okay. Someone's waiting.
Just grab the yellow one. There's something.
We're going to try this one? Even more. Okay, so we're really thrilled. I wouldn't have told you if only the sort of B and C options had accepted, but I can tell you that the A choices did and are here at my right today, and so it's a great pleasure to introduce them. Peter Biro is the founder and president of democracy think tank Section 1. He's a senior fellow of Massey College, a center associate of the University of British Columbia's Center for Constitutional Law and Legal Studies, and chair emeritus of the Jane Goodall Institute. Most recently, he is the editor of this wonderful collection, The Notwithstanding Clause and the Canadian Charter, Rights, Reforms, and Controversies. He steered through, those of you who've produced an academic collection after a conference, the conference took place in April 2022, and the book has been out for months. So Peter, like never, stopped pushing to get this thing into print. He's an adjunct professor in the University of Toronto Faculty of Law, where he teaches constitutional law in the GP LLM program. He didn't care enough to list it in the short bio, but he's a graduate of the McGill Faculty of Law, and I'm very delighted to have him back this afternoon. Jonathan Montpetit is a senior investigative journalist with CBC News, where he covers social movements and democracy. He holds graduate degrees in political science from the London School of Economics and McGill University, and in 2021, he was a Southam Journalism Fellow at Massey College. And immediately to my right, Marion Sandilands practices civil litigation, constitutional and administrative law at Conway Litigation in Ottawa. She has appeared before multiple courts, including the Supreme Court of Canada. She teaches constitutional law at the University of Ottawa, and she speaks and is published on matters of constitutional, public, and administrative law, She's provided expert comments on constitutional issues for university podcasts, including that of the David Asper Center for Constitutional Rights at the University of Toronto, and for the McGill Law Journal, and for national media, including the Toronto Star and Global News. A proud Montrealer by birth, she's a graduate of McGill University's Faculty of Arts, as Jonathan is, and the Faculty of Law, as are Peter and I. So you hold us all together, Marion. We're so delighted to have this group here this afternoon for the discussion. And Jennifer, take it away.
Okay, it's back to me. Thank you very much, Robert. We're now going to proceed to our roundtable discussion. We have lined up some questions for each of the panelists. They're going to try their best to answer them within around 10 minutes. We'll see how well it works. And following our roundtable discussion, we will open up the floor for a Q&A. So please collect all of your thoughts and responses, and we look forward to hearing them afterwards. So my first question goes back to Robert Leckey. So some audience members here today, myself included, are probably much less familiar with Canadian constitutional law than you and the other panelists are. So what do you think are the most important pieces of historical and political context we should have for discussing the Notwithstanding Clause?
So I think there's some first-year law students who began law school like 3 weeks ago, and there's some constitutional experts in the room. So I'm just going to do like my best effort at a sort of just quick overview, very quick, but of how do you sort of position things so that you can be an engaged listener for the rest of the discussion. I'll first say that like the idea that there's a clause that a legislature can invoke to override guaranteed rights and freedoms didn't come out of nowhere in the early 80s with the Canadian Constitution Act. The Diefenbaker Bill of Rights of 1960 also provides that the Parliament can legislate notwithstanding or despite its guarantees. But the Notwithstanding Clause in the Canadian Constitution from 1982 has attracted attention around the world from comparative constitutional scholars because it's very rare or unique to have something like that in the kind of national constitution's Bill of Rights. And so in the early 1980s, when the Trudeau repatriation project was being discussed, including the idea of a Charter of Rights, there were some provincial premiers who were concerned about the impact, including the sort of centralizing force of having an enforceable Bill of Rights that might interfere with provincial legislative policy. Ultimately, the package that was signed on to by every province except Quebec included Section 33, the Notwithstanding Clause, which provides that the Parliament of Canada or a legislature can declare in a law that, one provision or a statute or more than one statute will operate and produce its effects notwithstanding one or more guarantees in the Charter. And the sort of literature around the Notwithstanding Clause in the 80s reflected a range of perspectives. As I said when I was talking to law students about this recently, my oldest active alumnus is Manny Schachter from the class of 1947. And Manny has never digested that there's a Charter of Rights that has this kind of escape clause in it. So every time I see Manny, he's like, how can it be? And I'm like, well, I wasn't there, Manny, and it's in the Charter, and we have to live with it. But there are some who from the outset thought that this was simply, didn't make any sense that you would guarantee the rights and freedoms and then allow a legislature to sidestep them. But there were some very, very credible, very publicly minded people at the very beginning who could explain why they wanted to have the Notwithstanding Clause. Peter Lougheed thought that the courts might make a mistake in interpreting a judgment and that the legislature might choose to substitute its interpretation for that of the court. And when you look at the Supreme Court splitting 5-4 on a contentious issue, the 4 dissenting judges and sometimes all the other judges below, these aren't unreasonable people taking a different approach than what the majority ultimately decides. So one idea is the Notwithstanding Clause allows a legislature to disagree with the way a court has interpreted the Charter. Alan Blakeney in Saskatchewan was concerned that there were social rights that weren't included in the Charter. And he was concerned that one day the Charter might be enforced at the expense of other rights not captured by it. So he was concerned about a conflict of rights, the idea that there might be values that the Charter would interfere with were it not for the possibility of the Notwithstanding Clause. And what I'll just observe about those justifications for the Notwithstanding Clause, neither one is based on the idea that rights are fundamentally a bad thing or that courts applying rights are fundamentally a bad thing. So just sort of hold that in your mind because we'll see a little contrast as we come closer to the present moment. But through the 80s, there was discussion over whether this was a sort of miraculous squaring of the circle or whether this was a betrayal of the aspirations, but there was literature going on. And the political scientists tended to celebrate the Notwithstanding Clause more as kind of celebrating the power of democracy and the supremacy of Parliament. And some of the greater unease about the Notwithstanding Clause may have been expressed by some of the law professors writing in the law journals. It's a gross generalization, but you can track a little bit of those differences. In the early 80s, Quebec used the Notwithstanding Clause right off the get-go, sort of saying it's understood as a sort of protest move. But Quebec invoked the Notwithstanding Clause for its entire statute book, and it even purported to do so back 3 months to when the charter kicked into force. So that was the most dramatic use of the Notwithstanding Clause. Quebec has used it at other moments. Other provinces have used it now and again, more than sometimes people realize. But after the sort of first wave of literature in the 80s, I would say the conversation sort of settled down a bit through the 90s and early 2000s, and it wasn't used that much. And so in terms of why the book, why the conversation, why is it so relevant today, it's because in the last 5 years, there really has been a resurgence, I wouldn't say interest, I would say of use of the Notwithstanding Clause. And it's been used by Quebec, and it's been used by Ontario, and it's been used by Saskatchewan. So there is a Quebec dimension that a couple of our speakers will talk about, but it's not a Quebec phenomenon only. And so it's being used repeatedly. And I said a moment ago that the early defenders of the Notwithstanding Clause didn't hold themselves out as sort of fundamentally opposed to rights or a charter or courts interpreting rights. In their worst moments, some of the people using the Notwithstanding Clause in the recent examples give the impression that a majority government simply shouldn't be slowed down in implementing its agenda by a court hearing a plaintiff and enforcing the Canadian Charter. So it's not spelled into any of the laws, but Doug Ford in front of the microphone or Simon Jolin Barrette or François Legault at times sort of says, look, we just don't want people getting in our way. We have a mandate from the voters, and the Notwithstanding Clause is our way to do it. And so that's a slightly different justification for the thing than we had in the early 80s. So it's a shift. I would say that some of the defenses of it have shifted from what they used to be, and it's been used in consequential legislation. It's been used, so different constituencies have been affected by the recent uses of it. Quebec used it in 2019 in its laicity or secularism or religious symbols law, Bill 21. Quebec used it again in Bill 96 in 2022 in the revisions to the Charter of the French language. Ontario's used it a couple of times, once regarding municipal elections in Toronto, once regarding school employees. That one's an amazing case because it reversed course 10 days later, but it still used it. And Saskatchewan has used it recently to kind of put a shield around a law reducing the capacity or rights of trans and non-binary youth to have their names and pronouns used as they would wish in school. So it's being used across a range of issues, range of constituencies. And maybe the last thing I'll say just in terms of this setup is people talk about using the Notwithstanding Clause in a kind of binary way, you use it or you don't use it. But there are choices to be made by a legislator in how it's being used. So you can use it in a kind of targeted fashion. You can identify with razor precision that one clause of your law is going to operate despite a single right in the Canadian Charter. Or you can do, what in French they sometimes say mur à mur, I think of as the whole shebang, but you can invoke all the rights that the Charter can, that the Notwithstanding Clause can push aside or put into abeyance, and you can apply that to an entire statute. And that, to me, we'll come back to this, but that's a different kind of exercise, because in that kind of exercise, you're not saying, I disagree with the court on a particular issue. It looks a lot more like you're saying, I'm trying to sort of foreclose any kind of recourse to the courts and to fundamental rights. And so that's just, as one reads it, it's often framed, that they used it, they didn't use it. But as a kind of lawyer, you look at the mechanics, it can be used, it's a tool that can be used in a limited fashion or in a much blunter fashion, and we have seen it used in a pretty blunt way. Does that seem like a little historical political context?
I think that's the most excellent bit of historical political context in under 10 minutes I've ever heard.
So I'm going to stop.
Thank you. And I think you've really laid the ground well for the questions that we're going to follow up with. The next one goes right over to Peter, the editor of this volume. We've just heard from Robert that one of the driving concerns behind the emergence of this clause in the first place was about preserving the power of legislatures vis-a-vis the courts. So my question to you is, what power do the courts have to intervene when Section 33, the Notwithstanding Clause, is invoked?
Well, that I guess I would have to say is the second most important question we can ask. The first is, of course, whether we should have this darn thing in the first place. And maybe we'll have a chance to talk about that. But I don't think there's much of an appetite these days for constitutional reform, certainly not of the sort that would entertain seriously the idea of repealing Section 33, although I've been calling for it for about 30 years. Let me sort of interrupt myself first by saying thank you to MISC for having us here. I'm so delighted and so honored that we're here, and that the turnout is so fabulous. It means that the state of civic engagement and civic culture in Quebec is as strong as any place, probably stronger than any other place in the country, I would suggest. And I can say that having spent 4 years studying law here. I think that's true, and having lived and worked in other parts of the country. That's the first thing I wanted to say. The second is that I just want to note that somebody extremely important is not here who should be here, and his name was Benoit Pelletier. He contributed a marvelous chapter to this book. He was a great man of politics and a great man of the law. I'm sure that many of you know that. It was very, very sad. He passed away literally the week that this book was being couriered out to the contributors. So even to this day, which was a few months ago, I don't know if he ever got to see or hold a copy of the book. But if you do have the book, I hope you take the opportunity to read his chapter. And his argument is a serious one, and he was just brilliant, and we miss him. Now back to the question. The question that you ask, if I can just reframe it, I think really is the most important live question today. And that is, and I wouldn't characterize it as one of judicial intervention, what power does the court have to intervene, but rather what authority and jurisdiction does the court have to inquire into the effect and the significance of a law that has been enacted under cover of Section 33, the Notwithstanding Clause. What is the effect of a proper invocation of the Notwithstanding Clause? That is an invocation that is made in conformity with the provisions of Section 33, and there aren't too many requirements. One of them Robert mentioned, which was that they specify either in omnibus fashion all of the rights and freedoms in the Charter to which the clause applies, and those would be the fundamental freedoms in Section 2. Then Sections 7 to 14, the legal rights, and Section 15, equality rights. The other formal requirement is that it sunsets after 5 years. That one's really important, certainly for my answer, extremely important. What that means is that if a law is enacted with the protection of the Notwithstanding Clause that effectively says the law shall operate notwithstanding a provision in the Charter, which it may or may not offend, all right? That sunsets after 5 years, okay? And presumably the reason that it sunsets is so that the legislature or Parliament, as you probably know, has never yet exercised its authority to enact law under cover of the the Notwithstanding Clause, but it could. The idea is that the legislature would then have an opportunity to reconsider the wisdom of the law in light of the potential infringements, its deleterious effect on rights and freedoms, right? All right. The answer to the question is really the answer to the question, is the court's jurisdiction ousted? Is the court prevented from entertaining questions or grievances from members of society who want the court's assistance when they allege or complain that a right or freedom has been infringed by a law. The Quebec Court of Appeal in the Hack decision, Robert referred to it, Bill 21, La Loi sur la laïcité, just a few months ago, answered the question as follows. If the Notwithstanding Clause is properly invoked, there is nothing further for the court to declare. Even if it wants to, it cannot entertain an application to undertake judicial review. The only thing it's allowed to do is to ensure that the formal requirements of the invocation have been met. But it cannot inquire into whether, in fact, there's actually been an infringement. And more importantly, it can't even allow the parties, which would be the applicant, and the government, presumably, who's there to defend and answer for its law, to engage in an exercise of what's called justification under Section 1, the Reasonable Limits Clause, which I like to call the Liberal Democracy Clause, but that's for maybe another discussion. The clause under Section 1, which says a right may be limited if that limitation occurs in a manner that's consistent with our respect for rights, that's consistent with what it means to live in a free and democratic society. And there's a test that's established. It's called the Oakes test, and it's been refined in subsequent case law. That entire exercise of looking at whether the limiting law or the infringing law can nevertheless be justified in a manner that's consistent with our commitment to freedom and democracy, that doesn't happen under Hack, under the Quebec Court of Appeal. On the other hand, in Saskatchewan, the UR Pride case, the Parental Bill of Rights case that Robert also referred to, and which, by the way, cites him with approval and relies very much on his analysis, which, by the way, I happen to think is the correct analysis, took the opposite position. And it said, granted, if the Notwithstanding Clause is properly invoked, we agree and accept and acknowledge that the law shall be allowed to operate notwithstanding the charter provision that may be offended or infringed. However, that doesn't oust our jurisdiction from commenting further and from granting other relief short of striking down the law under the Supremacy Clause, Section 52 of the Constitution Act 1982, which basically says, you know, if a law is inconsistent with a provision in the Constitution, in the Charter, it shall be of no force and effect. So that remedy's off the table. But the Saskatchewan Court of King's Bench said, we can still comment on the law. We can still say the law does infringe or does not infringe, and we can inquire into whether that infringement could be justified under the Section 1 test. And as a matter of fact, next Monday and Tuesday, arguments will be made before the Saskatchewan Court of Appeal, appealing the decision of Justice McGaw of first instance on this very issue. But this is a matter where the stakes could not be greater for us as a democracy. And that's why I appreciate the question. How much time do I have left, by the way? Just tell me.
2 minutes.
I got 2 minutes. I'm going to use them. So here's the thing. We can look at this question, what's the right answer? Well, the Supreme Court's going to decide, is really going to answer this question definitively, because Hack is going to go up to the Supreme Court, and ultimately UR Pride will go up to the Supreme Court. I hope that they side with Saskatchewan, not because I like that, but because I think that's the correct position for a couple of reasons. Number one, and Robert and Grégoire Weber, who wrote an amazing chapter in this book, which I urge you to read, have sort of analyzed the question of how Section 33 operates within the broader architecture of the Constitution. And they take the position, I think quite rightly, and the court in Saskatchewan accepts it, that the court's jurisdiction is not ousted. The effect of Section 33 is simply to allow an infringing law to continue operating, okay? So from the standpoint of the construction of the provision, I think that's the correct view. But there's another reason it's correct, and it may be more important, and that I would frame it this way. What does a liberal constitutional democracy require and demand of us? What kind of accountability is required for us to call ourselves properly a liberal democracy? And there's a clue right in Section 33 about what the correct answer should be. Section 33, as I mentioned before, contains the sunset clause. The idea is there should be deliberation. There should be this ability for citizens to get the benefit of an authoritative position, opinion, commentary, not to mention possible declaratory and other relief under Section 24. Get the benefit of an authoritative, reasoned position on whether there's been an infringement, what its effect is, whether it survives the Section 1 test, from a court of competent jurisdiction, the institution which, after all, is best and most qualified to opine on such matters. If Hack is correct, and I'll stop with this sentence, and the court doesn't have jurisdiction to go there, our entire society, including the legislators who will possibly debate this issue upon the sunset, don't have the benefit of an understanding of what the effect of that clause was in the first place. That's highly problematic. And there's one other question, which I'll just leave hanging. If the court didn't opine on this question, what is the effect of the law on the moment of sunset if there isn't, or what's the effect of the law if it's reenacted without the ability to know whether there's been an infringement or not? I'll stop there, and maybe we'll have a discussion about this a little later. Thanks for letting me go over.
Oh, my pleasure. You're adding more questions to our questions, so it's more food for discussion. We're going to turn now to Marion. Marion, your chapter in the book is all about how Quebec has used the Notwithstanding Clause recently in Bill 21 and Bill 96. To what extent would you say are the concerns about Section 33 a Quebec issue?
I'll give you the ultimate lawyer's answer: yes and no. So it is and it isn't a Quebec issue. There are some things that are very specific to Quebec's context, but I argue the precedent spills over and makes it very much not merely a Quebec issue. Before I dive in, I'd like to thank MISC and the Faculty of Law for organizing this event and for inviting me to be on this very esteemed panel. And thanks to Peter for making this project happen, bringing us all together. Monumental. I'm glad to be here today. I do have things to say. So I come to this question in the course of my law practice, kind of stumbled into it. I represent minority language organizations in Quebec, and they're directly affected by Bill 21 and Bill 96. So I represent one of the interveners in the Bill 21 case, so I'm living it. And I've taken a very deep dive into both Bill 21 and 96 and thought a lot about how Section 33 is used in those laws. And what I noticed, and what my chapter is about, is Bill 21 and Bill 96 use Section 33 in a very deliberate, very broad, and very unprecedented way. So Dean Leckey alluded to this before. I call it the broadest override of human rights statutes in Quebec's history. And in my chapter, I go through in painstaking detail why I say that. Yes, Quebec used Section 33 in an omnibus fashion back in 1982 to protest patriation of the Constitution without Quebec's consent. But at the same time, and this was Premier René Lévesque at the time, Quebec actually promoted its own human rights law, the Quebec Charter, to kind of stand in for the Canadian Charter. So at that time, Quebecers effectively had the same rights under the Quebec Charter, even though they had kind of blocked the application of the Canadian Charter. And so Bill 21 is quite different from that, because Bill 21 blocks both the Canadian Charter and the Quebec Charter at the same time in the most broad way possible. So the goal here, the stated goal, is to cut off human rights recourses, and preemptively, before a court has had a chance to weigh in. And that's a first. It's a big first. And Bill 96 was the second. So the proponents of Bill 21, some of whom are in this book, including Guillaume Rousseau and François Côté, had published a paper in 2020 comparing the use of Section 33 in Bill 21 to a volcano. And Guillaume Rousseau has a chapter in this book, and he and I have a very lively disagreement about a lot of things. But what we do agree on is that Bill 21 and Bill 96 represent a major change for Quebec. And it's a unilateral change. I think it's an attempt to reconstitute Quebec unilaterally, and I would add with very little public awareness. In the 2020 paper of Rousseau and Côté, I quote from it because it's so interestingly written. They say, quote, "Legal theories and practices can sometimes be compared to volcanoes. Formed in the past and remaining quiet for ages, these peaceful giants in the background scenery appear dormant, taken for granted, uninteresting even, save for a few experts, until one day they erupt in the most spectacular fashion in a sudden torrent of heated activity that changes the entire landscape." Those aren't my words. Those are the words of the architect of Bill 21 and Bill 96. So in my chapter, I go into a bit of constitutional history, and I argue what we're seeing in Quebec is indeed an eruption of this constitutional volcano, but perhaps it's an underwater volcano. We don't really see the eruption, but it is fundamentally altering the geography of the ocean floor. So I've studied this, and what we see with 21 and 96 is a reordering of the legal hierarchy in Quebec. With 21 and 96, we see entrenched human rights being demoted from fundamental and in first place to down to third place, being put beneath these other two laws. That's a massive change. And I will begin to close by reminding us what are rights and constitutions for. In the liberal constitutional tradition, rights and courts provide a check on state power. So when we see premiers using the clause recently, these are premiers whose political party controls the legislature, and they also control the executive branch. And by invoking Section 33, I see an attempt to remove the one remaining check on their power, the judicial branch. So yes, it's a big change. And there's been surprisingly little public discussion about this, how fundamental it is. I think Robert Leckey in his 2019 paper called it a paradigm shift or radical shift. And contrast this with the all-consuming discussions that happened in the 1980s and 90s around the Constitution and Meach and Charlottetown and referendums, right? That's not what we're seeing now at all. So that's why I call it an underwater volcanic eruption. You don't see it while it's happening, but one day when you look for the ocean floor, it's not where you thought it was. So to get back to the question, is this just a Quebec thing? Well, there are some things that arose in the Quebec context and are important to understand in their full context. But I think the underwater volcano analogy actually does work across Canada in terms of the way that the use of Section 33 is changing the norms in a fundamental way. So as Dean Leckey said, we've seen in the last 5 years a resurgence of the clause. It's used about once a year now, where prior it was used rarely, maybe like once a decade. The trial judge in the Bill 21 case says that this trivializes fundamental human rights, this sort of broad, sweeping use. It's set a precedent in Quebec, and it's also setting a precedent in other provinces. So Ontario, Quebec, and Saskatchewan so far, I've studied the legislation, and they mirror each other. They read each other's statutes, and they copy one another. And now what we have is an established practice where we didn't have one before. And it becomes less and less of a big deal each time it happens. So for example, how many of you are aware that the National Assembly invoked it again this year in 2024? It was the 5-year renewal on Bill 21. Barely made the news. So the trivialization of human rights and constitutions in general, I say, is especially worrying in a world with liberal democracies under threat. Our human rights and our constitution is supposed to be our bedrock. But like the ocean floor after an underwater eruption, it's no longer where we thought it was. That's not merely a Quebec issue. And I'll close by saying I don't think the most important question is what will the Supreme Court decide in the Hack case, or what will the Saskatchewan Court of Appeal decide in the UR Pride case. I think it is what kind of democracy do we live in? And I think the answer doesn't lie with the Supreme Court or the Saskatchewan Court of Appeal or the Quebec Court of Appeal. I think it lies with all of us.
Okay, thank you very much. So we're going to go from a more Quebec-focused question initially to a more non-Quebec-focused question, at least at the outset, for Jonathan. And we've already heard we've just now from Marion has asked the question, what kind of liberal democracy are we living in? Peter said that one of the main questions for him right now is what does liberal democracy require to function? So we're going to go off on the topic of liberal democracy with Jonathan. Your chapter in the book is entitled The Rise and Fall of Liberal Constitutionalism in Quebec. What do you mean by liberal constitutionalism, and how would you say it is faring outside Quebec as well?
Thanks, Jennifer. So, a quick caveat here. So I'm, as you're about to find out, very much not a lawyer, very much not an academic. My observations here are based on extensive reporting about Bill 21 and more recent reporting about developments in conservative politics in Canada. So I think in a lot of ways, my chapter, the title of the chapter about the, what do I call it, decline and fall, or the fall of rise and fall of liberal constitutionalism in Quebec, kind of, is a way of describing the consequences of what Marion's chapter outlines. So I make the argument in the chapter that basically the developments with Bill 21 and Bill 96 herald the fall of liberal constitutionalism in Quebec. And in the chapter, I cite a University of Chicago law review, which I thought did a pretty good job of summarizing what you could call the necessary conditions of liberal constitutionalism. So, things that we're all pretty familiar with. I think, a schedule of individual rights enshrined in a written document that is not easily amended, independent judicial review, elections, rule of law. More generally, I think liberal constitutionalism, liberal in the sense that while democratic, it is worried about the excesses of executive power and majoritarianism, which is a little bit distinct from more Republican strands or radical democracy strands of democracy. And it's constitutional in the sense that it looks to a kind of prescribed rules of countervailing institutions to limit the excesses of majoritarianism and executive power. And I think, so as part of my argument, is that to a certain extent, liberal constitutionalism describes a broad cross-party effort in Canada that has existed at least since after World War II. And my chapter shows that liberal constitutionalism in Quebec enjoyed support from both sovereigntists and Federalists, and in particular, a key figure in the Quebec human rights revolution, a key figure in the development of the Quebec Charter of Rights, Charter of Human Rights, is Jacques-Yvan Morin, who was a law professor who then became an M&A for the Parti Québécois. And so I think, the fact that both provincial liberals and the Parti Québécois would have backed forms of liberal constitutionalism is indicative of the kind of hegemonic status that it enjoyed, at least for a certain period in Quebec. And, when Robert was kind of giving his overview of the use of the Notwithstanding Clause and Quebec's invoking of it in 1982, it didn't invoke it for the Charter of Human Rights, which again, I think is an indication of that while Quebec had an argument with the federal charter, there was still broad support for having a charter of rights, a charter of human rights, operational in the province. I think that a similar consensus existed at the federal level. Diefenbaker, obviously, his Bill of Rights paved the way for Trudeau's charter, and even the way Brian Mulroney expressed his objections to the Notwithstanding Clause, it made clear that he still believed in human rights, and I think you can hear in his arguments a commitment to liberal constitutionalism, and so again, this is kind of the background the background understanding that I enjoyed cross-party appeal. Now, I don't think that in and of itself using the Notwithstanding Clause entails a damaging blow to liberal constitutionalism. It's been used for more minor issues like expanding no-fault insurance, and certainly in the book there's a really interesting chapter by Christopher Manfredi who makes a very compelling argument about how the Notwithstanding Clause is integral to liberal constitutionalism. But I do think that the way it's been used recently, both in practices and like actually subject of a law, but also just the way that it is invoked. Lots of premiers refuse to rule out now using the Notwithstanding Clause. So the way that's kind of been used recently in Canada, I think signals that liberal constitutionalism is coming to something of a critical juncture. And I have in mind a particular subset of examples. Not surprisingly, Quebec's use of the Notwithstanding Clause in Bills 21 and 96, and Saskatchewan's use in Bill 137, which is the Parental Bill of Rights. And Saskatchewan's Parental Bill of Rights follows very closely policy in New Brunswick. Premier Higgs there has not invoked the Notwithstanding Clause, but he has said that he has not ruled out using the Notwithstanding Clause to protect his pronoun policy there. So I just want to make 2 points about these sets of cases. The way I think that a lot of the normative debate is framed when we talk about the Notwithstanding Clause is kind of focuses on the tension between judicial independence on the one hand and parliamentary supremacy on the other. Or to phrase it more partisan terms, unelected elite judges versus the will of the people. But I think in the cases that I mentioned, and this picks up on a point that Marion made, in the cases that I mentioned, I think it's worth pointing out that there are exercises of executive power at the expense of the usual legislative process. So, for example, the CAQ government invited very few Muslim women to testify before the legislative community while studying Bill 21. So that meant that lawmakers were not hearing much from the people who would be directly affected by the law. The CAQ used closure to prematurely end debate over Bills 21 and 96 in order to pass them. In Saskatchewan, it was revealed during the injunction hearings last fall that the government conducted very little formal consultation with teachers or other stakeholders before drafting their policy. And despite the government claiming that there was a groundswell of public opinion for its policy shift, access to information requests revealed there were in fact no more than a handful of letters of support, and it is not actually clear whether those letters were even written by parents of children in the schools. So in these cases, Notwithstanding Clause is being used to shield laws or policies that suffer from a certain democratic deficit. And it enables bypassing of legislative procedures that are a core feature, I think, of liberal constitutionalism. Right? These deliberative aspects are kind of meant to, at least in the liberal constitutional perspective, kind of calm the passions of the legislature. The second point I want to make, the premiers using the Notwithstanding Clause to override minority rights, basically they're using it to override rights that are deprioritized in some way, seen as less important, too far demanding on other social goods. And I think there's an important echo here with a line of conservative thought that, while not exactly new, is gaining influence over a more familiar strain of conservatism. This more familiar strain sometimes gets called neoliberalism, classical liberalism. It's broadly libertarian. This was, I think, would have been true both of economic policies, free market, that kind of stuff, and even the social conservative policies that this kind of conservatism would support. For example, invoking religious freedom to argue against same-sex marriage. This is still a rights-based argument. And so this older or more, I think, what would have been more familiar brand of conservatism still, I think, would have been compatible with liberal constitutionalism. This newer or resurgent brand of conservatism, I think, amplifies a critique of liberal institutions, such as individual rights, judicial review, because it claims that these innovations have undermined older, more communitarian institutions, such as the family or the nation, undermine notions of the common good that may be a little bit less pluralistic. And importantly, this is a mode of conservative thought that is critical of consumerism, which is another way that it's different from the kind of free market conservatism. And from this perspective, I think it sees basic notions of identity and subjectivity, such as race, gender, and some religions. It sees these things as kind of matters of choice that have been enabled by excessive liberties. It's part of what some conservatives see as a post-materialist turn in society, and that's why I think some of these subjectivities get derided as trendy, which is, I think, I'm quoting here from Premier Higgs and how he's referred to some teens who identify as trans. So I think the danger here for liberal constitutionalism is an emerging trend where executive power, not legislative power, but executive power is being used to dodge accountability in order to repress or suppress identities that are perceived to be hostile to a common good.
Okay. Well, thank you very much to all four of you for providing such excellent responses, food for thought, and also so admirably within the time limits you were given. It's very rare that happens on a panel. We've given the audience a lot of